Welcome to the latest episode of Dan Talks. Today our conversation will once again be turning towards patents, more specifically the unjustified threats provision in section 128 of the Patents Act 1990. People who have taken the time and expense of acquiring the rights of a patent want to be able to protect those rights from potential infringers. As the cost of litigation regarding intellectual property can be expensive, patent holders often take steps before litigation to protect their interests. This includes threatening legal action against people who they feel may be in breach of their patent. It is important patent holders are cautious when threatening a potential infringer, as in some circumstances this can result in a threatened party claiming an unjustified threat was made against them. The purpose of the unjustified threats provision is to prevent patentees throwing their weight around by threatening litigation in circumstances where the threat cannot be justified, or in situations where the person threatened has not actually infringed the patent. Traders should be free to conduct their business without the threat of litigation hanging over their heads, so the unjustified threats provision acts as a protection for them. An example where the provision is relevant is as follows. Mariah holds a valid patent and believes that Jennifer may be infringing on her rights, so corresponds and threatens legal action to stop her from her alleged infringement. If Jennifer is not in breach of anything and feels as though these threats are not warranted, she may seek relief for these unjustified threats under a section 128 of the Patents Act. Jennifer, under this section, can apply to the court for a declaration that the threats are unjustifiable, an injunction against the continuance of the threats, or the recovery of any damages sustained by the applicant as a result of the threats. So what are the elements for someone like Jennifer to establish that an unjustified threats provision applies? The first element is delivery. This element looks at the way that the threats can be delivered or communicated by the patentee to a competitor or alleged party in breach. In section 128, it refers to a threat being communicated by means of circulars, advertisements, or otherwise. However, the courts have interpreted this more broadly to include threats communicated orally, in letters and writing, via advertisements, and/or on the packaging of the product itself. For the communication to be actionable, it must constitute a threat. This leads us to the second element, that a person was threatened. This element looks at what constitutes a threat. The current test of what constitutes a threat for the purpose of section 128 stems from the case of U&I Global Trading and Tasman Warajay, 1995. In this case, Justice Cooper said a threat would be present if the language used would convey to any reasonable person that the author intended to bring proceedings for infringement against the person said to be threatened. It's not necessary that there be direct words that action could be taken. It is also important to note that under section 131 of the Patents Act, the mere notification of the existence of a patent does not constitute a threat of proceedings. The third element is that the threat must be unjustified. A threat will be unjustified if the patent owner cannot make out a case of actual infringement of their rights. We'll take a look now at the case of Mitzi Family Holdings and Morelli, number 3, to see this in action. In this case, Mr. Mitzi and Mr. Morellini together developed a cane billet planter, but Mitzi applied for a patent first and claimed that Mr. Morellini had breached his patent. Mr. Morellini claimed unjustified threats as a result of an article and notice printed in Cane Growers magazine. The article by Mr. Herlog, Missy's attorney, warned sugar farmers of the danger of copying patented inventions, while the notice set out information concerning Mitzi's billet planter. It was found, although not directly targeted at Morellini, the article and the notice did constitute unjustified threats towards him. Thus, because there was no breach of patent by Morellini, the threat by Motti towards Morellini was not justified. Under section 129 of the Patents Act, there are situations where a threat can be justified. Generally, if a patent owner satisfies the court that the acts of the alleged infringer did in fact infringe the rights of the patentee, then the threats will be justified. There you have it, the unjustified threats provision explained.